Thank you, everybody. Welcome. We are looking forward to hearing from you. My name is Darcy Kern. I'm a professor of history at Southern Connecticut State University.
Good morning. My name is Jamie Gass. I'm director of the Center for School Reform at Pioneer Institute. It's a Boston-based think tank that does research on K-12 education reform.
Good morning. My name is Tim Isaacs. I am director at the Center for Teaching the Rule of Law at Roanoke College in Salem, Virginia. And congratulations for making it to the national finals. I'm sure you're happy and looking forward to it.
Could you guys please introduce yourselves and your teacher?
Hi, my name is Gwyneth Hiller, and I'm a senior at Easthampton High School.
Hi, I'm Shane Cudworth, a junior at Easthampton High School.
Hi, I'm Zach Clapp, a senior at Easthampton High School, and this is our teacher, Kelly Brown.
Thank you. Well, I'm going to read question 2 for you, and then we will hear from you and then have a discussion about it. So, question 2. Parliament passed the Habeas Corpus Act of 1679. What is habeas corpus, and to what extent, if any, is it essential to the principle of limited government? How has the writ of habeas corpus evolved in the United States? Under what circumstances, if any, might the writ of habeas corpus place an unreasonable burden on the government? You may begin.
Dating back to the Roman term de homine el libero ex habendo, habeas corpus, simply defined, is a person's protection against illegal confinement and serves as a necessary protection of the people from their governments. The modern version of the writ of habeas corpus originates in the British Constitution and common law, beginning with Article 39 of the Magna Carta, followed by the Petition of Right, Habeas Corpus Acts of 1640 and 1679, and then realized in the English Bill of Rights. Parliament defined a legal process at which one could appeal their imprisonment, if viewed unlawful, ensuring the king did not abuse the rights of the people to consolidate his own power by silencing critics. Today, we believe this check is still necessary, especially within our own limited government's presidential system. For if the purpose of limited government is to ensure liberty for the pursuit of happiness, a limited government cannot exist if the people live in fear of arbitrary punishment, a frightening thought within our modern, polarized, gridlocked political atmosphere.
The founding generation was intimately familiar with habeas corpus violations during the imperial crisis as Parliament suspended the Great Writ during the Revolution, imprisoning many Americans. Thus, the founders included the privilege of the writ of habeas corpus under Article 1, Section 9, Clause 2 in our U.S. Constitution. That said, habeas corpus has been most clearly defined by federal and state statute through acts such as the First Judiciary Act of 1789. Additional expansions to habeas corpus pre-Civil War served to advance congressional motives, as seen with the Force Bill of 1833 and the 1842 Habeas Corpus Act. During the Civil War, the Restrictions Clause in the Constitution gained further clarification in the Ex parte Merriman case, in which Chief Justice Taney ruled that the suspension clause was limited to congressional powers, though scholars such as Akhil Amar claim that Justice Taney was incorrect in his arguments.
Post-Civil War, Congress further expanded the writ. The Habeas Corpus Act of 1867 allowed for habeas relief to formerly enslaved people being held as state prisoners if they were held in violation of federal law. Additionally, the 14th Amendment's incorporation process, by which the Bill of Rights was applied to the states, allowed habeas corpus to become a tool by which criminal defendants argued their state convictions were in violation of their federal constitutional rights. Post-World War II, the Warren Court further paved the way for broader habeas corpus rights.
In 1996, Congress narrowed the writ of habeas corpus through the passage of the Prison Litigation Act and the Anti-Terrorism and Effective Death Penalty Act, which both reduced the number of habeas corpus petitions prisoners were capable of filing to challenge their conviction and limiting the effects of Jones v. Cunningham. The limitations set by ADPA were made worse through cases like Lockyer v. Andrade. Habeas limitations continue with the Detainee Treatment Act and the Military Commissions Act, which further narrowed the scope of habeas relief, providing that prisoners held in Guantanamo Bay may not access the federal courts through habeas corpus. Instead, they must go through the military commissions. Recently, the Supreme Court has expanded the right through cases like Boumediene v. Bush, which ruled that the suspension clause affirmatively guaranteed the right to habeas review.
The importance of the writ of habeas corpus should be weighed above any burdens, as it is necessary for due process rights and limited government. State constitutions do hold the most habeas corpus hearings, which can incur significant costs, but this is an important cost of detention. There are times in history when governments complained to the burden, as seen in the Jim Crow South, but these claims were based on an institutionally racist system resisting federal intervention.
The War on Terror brought in a new area of habeas law that showed gross violation in the name of lawful suspension, such as the use of black sites for detention, interrogation, and torture. Despite the verdict in Boumediene, out of the 780 people who were detained at Guantanamo, 40 remain and only 7 were charged. The stories of people like Mohammed Oslai, who was detained for 14 years with no charge and was brutally tortured for months, are not only unconstitutional, but should not be considered burdensome. Thank you. We're ready for your questions.
Great, thank you. My first question for you is the government ever justified in trying someone in absentia?
I apologize. Your mic cut out at the end for me. Could you repeat your question?
Sure. Is the government ever justified trying someone in absentia if the person is not present?
No, I don't think so. I think that is a violation of the due process rights guaranteed within the US Constitution, especially the ones involved and ruled within not Russell v. Bush, I apologize, Hamdi v. Rumsfeld, which argued that people were guaranteed due process rights within both military tribunals and civilian courts, although it was largely focused on the military tribunal that Hamdi was tried in. I think that to be absent and still ruled upon without your consent, without you being able to have to testify on your behalf, to see the evidence tried against you, is a strict violation of what we've guaranteed within the US Constitution and human rights in of itself.
I agree. I think having your case be ruled when you are not present is a violation of your rights and would not allow you to see if they are violating any due process rights. It's simply not fair to the person ruling and a violation of their fundamental due process rights.
When James Madison, the father of the Constitution, was president during the War of 1812, New Englanders threatened secession, and the British even burned the White House. Still, he never suspended habeas corpus or abridged domestic civil liberties. Why do you think President Madison showed such constitutional restraint during wartime?
Well, for starters, I personally believe that suspending the writ of habeas corpus, even within the Civil War by President Lincoln, should not have occurred. I think that any suspension of human rights in favor of the state motive is a human rights violation. If I were to be idealist, I would like to think that Madison recognized that by suspending the writ of habeas corpus, he was violating human rights. But if I'm being more realistic, it was more likely that he knew that since New England was already threatening to succeed by detaining individuals for that viewpoint, he was likely going to push New England to secession, which would threaten the Union.
I agree. I think being one of the main contributors to the Constitution, he saw the importance of the writ of habeas corpus. It is one of the few actual rights that are actually included in the Constitution in Article 1, Section 9, Clause 2. I think he probably valued the right, and even experiencing the British rule and the British's violations of habeas corpus, he, agreeing with Gwen, knew that if imprisoning them and sort of restricting the right of habeas corpus would only make the entire situation worse.
I very much agree that it was definitely a very important right to them that they had seen violated in the past, and then went on to put in state constitutions and one of the few rights in the actual Constitution. And also that I believe it should not be a right that is taken away, even though it is given as something that can be taken away in a case of emergency. I think it is a very important right, and it's something that should not be violated like that, even if there is something going on.
Excuse me. What are some other parts of the Constitution that protect against arbitrary incarceration?
You see other due process rights in Article 3, where it outlines the Supreme Court and as well as some due process rights like the right to a trial by jury. And I think that they included these rights because it was just important to them that people have a fair way to be tried in their country. And just the fact that a lot of due process rights are included in the Constitution, like habeas corpus or your right to a trial by jury, show that they wanted to protect the people from an oppressive government that might try to imprison them or unfairly convict them.
Additionally, you see in the Fifth Amendment protection against things such as double jeopardy or the securing of a grand jury. Additionally, Article 1, Section 9, Clause 3 protects you against bills of attainder, which would be Congress just ruling that you were guilty and subjecting you to detention, as well as prevention against ex post facto laws in which you are tried for something that you had already done previously before the law was put in place. Both of which they believed were absolutely necessary to the protection of liberty and included within the body of the US Constitution.
Okay, thank you.
You seem to be tilting heavily in favor of the right of the individual, particularly in this instance. Is there ever a time when the state does need to suspend a writ of habeas corpus? And if so, who determines?
I might be considered radical in this sense, but I don't think there should ever be a time in which habeas corpus is violated. Looking at it historically and in modern sense with the Guantanamo Bay cases, and currently the cases ruled for like Jennings v. Rodriguez and Zawades, I can never say it, v. Davis, they stated that they could detain people in ICE detention centers and not even give them bond trials in both of those cases. And in Guantanamo Bay cases, they continuously attempted to violate the individual's right of habeas corpus. And it was the Supreme Court that had to come in and say you could not violate them because you considered them enemy combatants. Just those two series of habeas corpus violations makes me feel as if habeas corpus should never be violated because it seemed to be perpetuating Islamophobia, racism against Mexican individuals, and for like they're not even properly like addressing the issues they're meant to solve. Also, the people convicted in Guantanamo Bay, a lot of them were innocent, and it doesn't solve the immigration crisis to wrongfully detain a lot of individuals, some of which aren't even immigrants, but people who were born in the United States initially.
I agree. And I think that in most instances, states have not suspended the Great Writ. That has been mostly at the federal level when there has been a crisis. And I think that if the states were to suspend the writ of habeas corpus, it would cause even more violations than what the good might be at that time of suspending it. I think states are one of the main places where you see rights violated. And if they are now suspending people's right to challenge their detention, it'll just cause tremendous problems and tremendous violations. In the Jim Crow South, you see the South continuously violating and wrongfully convicting formerly enslaved people. And it was up to people going to the federal courts to see relief from that. And I think that states suspending it would only be a bad thing.
I agree with Shane very much, and I think that the problems of wrongful convictions continue very much today. It's still very much genuinely an issue for people to be wrongly convicted, and then if you take away their right to that there be a reason that they are arrested, and their right that they can contest this, and that they can argue for themselves when the government has mistreated them like this, is very important. You see a lot of wrongful convictions. There's the whole Innocence Project of just trying to get people out of jail when they shouldn't be there. There's the Central Park 5 and so many issues. And on top of that, we have stuff like Guantanamo Bay. Like, there's so many reasons that it's important that we don't continue to allow this to be violated. Great,
thank you guys. Look, that was very good. That was a fascinating discussion that you had in the follow-up. I really liked how you answered both of my questions. Let me see, Shane bringing in the states, you guys talking about in absentia being a violation of due process. You mentioned the Rumsfeld case. I think that was good because I think this is an issue that we're having to deal with American citizens going to fight overseas. I thought this, start to finish, you guys were very, very good. You know the issue, very specific Supreme Court, state, legislative issues. You have the philosophical and the English background for this question. Yeah, it was a pleasure to hear you.
I was impressed with a couple of things, and I'm going to start off with some non-content things first. You're a small group, and that's always kind of difficult. But the continuity, the transition from one speaker to the next was very smooth. It was a seamless presentation during your 4 minutes, and it was a seamless presentation on the follow-up question. So congratulations for that. In terms of content, I would agree with my colleague that you hit all the big items, from the origins in the British constitutional documents to the American Constitution, court cases, times when it didn't work, times when the government stepped in and said, no, wait a minute, you've gone too far. I was really waiting for one of you to make the comment about the Jim Crow South, and you did, because a number of groups, when asked that question in a similar vein, forget about Jim Crow South. I mean, that's a classic example of where the states, fail and the federal government has to step in. So overall, very well done. Quite impressive.
Yeah, I'd like to echo much of what my colleagues have said, and I want to start by thanking you and your superb teacher for all of your hard work. This is really difficult material, and you handled it very, very nicely in a thorough and very comprehensive way. I thought in your introductory remarks, the direct connection with antiquity, but also Magna Carta, like your reference to the imperial crisis. I think that's the way the framers and the revolutionary generation viewed it, as an imperial crisis. I like that. I think you're the first one that we've heard thus far that made the direct connection with the 1789 Federal Judiciary Act. That is key. I thought that you brought your knowledge forward in the question, which I think is a difficult question. I think you handled my question about Madison, the War of 1812, which I have to say is a harder question. You handled that very well. You provide a very clear rationale, Madison being a framer and not wanting to set a bad precedent, but also the political realities that he was dealing with too. And you went really beyond that with mentioning other potential areas where civil liberties can be violated with things like bills of attainder and ex post facto. So you should be very happy. It's really strong performance.
And good luck the rest of the day.